Acts as Data Protection Officer for a large number of organisations in England, and today we're going to be discussing NHS proxy access to patient records, commonly called proxy access for short. Bear in mind this advice is based on current England practice. Things are slightly different to the other UK nations, but hopefully this will be useful to everyone. This video does not constitute legal advice. For customers wanting informal Data Protection Officer advice, please contact us via the usual routes. Okay, so what is proxy access? Well, it's how a parent, a carer, a relative, or even a friend can access someone else's medical records to view, book appointments, make prescription requests, and perform other activities. Obviously, this is only granted in limited circumstances. We're going to discuss them all here. We're going to talk separately about adults with normal capacity, adults without capacity, and children, because they're all slightly different. So, to get any form of proxy access, you generally need to discuss it with the GP practice. Your GP may have particular routes and forms for that. Please ask them because this does vary a bit. There's an online request system currently being trialled in England, but that's limited to a small number of practices. So unless your practice is a member of that group, you won't be able to use that. So from now, we'll leave it to one side. So for patients who are adults with capacity, okay, and that means that they can make decisions for themselves, okay, the basic process is that the patient makes the application stating who they want to have access. That's then reviewed by the practice and the GP grants it or refuses it. If access is granted, you can then access via the NHS app, local patient apps for your GP, which vary a lot depending on the system they have, or via telephone, email, etc. It's almost always necessary to prove identification of both the patient and the person being granted proxy access with photo ID or other documents before that can proceed. Again, that's just for patient safety. Now, obviously, your GP practice needs to protect vulnerable patients, so they may ask to speak to the person whose records are being accessed separately, or make an assessment if there's potential coercion or potential coercive control involved. If there are known safeguarding issues, these will also be taken into account. Separately, practices must consider that all access granted must be in the patient's best interest. So sometimes applications are turned down. There's no right of access to another person's records here, it's a privilege. After proxy access is granted, the patient can also change their mind at any time and inform the GP they want access removed. So, what about patients that don't have capacity? So if you've got a patient who doesn't have capacity because of illness or mental impairment or lots of other reasons, then the person asking for access must have either a lasting power of attorney for them for health and welfare, signed off by the court protection, or if the patient never had capacity or had already lost it by the time application was made, a deputyship from the court of protection for health and welfare. Note that the finance and property one isn't the same here. You have to have health and welfare. The GP practice will obviously need to verify these documents, and they can do that online, but they may ask for stamped paper copies from the court simply because it's quicker and easier. The online process can take up to a week or so. Note that if patients granted power of attorney, that can be exercised while they still have capacity. That's not a common situation, but some patients do it. Okay, that can be used too, but the GP will generally confirm where their patient has capacity, that it's the patient's wish as well as their best interest. So that covers adults. So what about children? Well, generally children have the same rights as adults, so it's never ever as simple as a parent saying, I want access and it being granted. We'll look at this in a bit more detail. Firstly, the person asking for access must have parental responsibility. That doesn't mean that the person being granted access is the biological parent, but the person asking must have formal parental responsibility. This generally has to be evidenced. It can't be assumed unless the practice is very clear on the identities of the individuals. So please don't be surprised if you're asked for evidence. It's a normal process. Parental responsibility is very much misunderstood. It's got nothing to do with whether the person lives with a child or even is biologically related to them. It can only come from a very small number of sources. The first one is a birth certificate naming that person as a parent. The second one is a parental responsibility agreement with the birth mother, signed and witnessed by a family court. It's got to be signed and witnessed. It can't just be a written agreement. Or a family court order recognising the requester as having parental responsibility. Again, that's a formal document. No, in surrogacy, adoption, long-term fostering situations, one of these should apply, or a formal court document will exist to evidence parental responsibility. Sometimes the local authority has parental responsibility, but they can ask on behalf of someone else for access to be granted. That's common in looked after children situations, for example. This all means there can be more than two parents, and that biological gender is completely irrelevant except in the birth mother case. So be clear that in surrogacy and adoption arrangements, plus in some cases where the child's taken into care, the biological parent can lose parental responsibility. Now, if parental responsibility has been removed, it can also be removed by a family court order, then you can't have proxy access. Now, in most cases, the practice would be informed by another parent or by the local authority of this happening. But again, this is evidenced by a court document. There's got to be a document here. It can't be hearsay, can't be, I don't think this person should have access. It's got to be a document. Also, in most cases with the child safeguarding issue on record, there will be caution exercised. That will generally be consulting the safeguarding team before action is taken. As always, it's the patient, in this case the child, patient's best interests that are being looked at. So, we verified the person requesting has parental responsibility. What next? Well, it's a good idea to check the other parents are aware. They don't have a right to veto, but they may produce evidence the person has had responsibility removed. So it's one of those cases where it's a good idea to check. Now, assuming all that's okay, we now look at the child. If the child is under 11 years old, 11, okay, 1, they are assumed to be able to manage their own information. Not to be able to manage it, sorry. So we can grant access if we believe it's in the child's best interest. That's under 11, okay, when they go from junior infant school into primary primary school into secondary school. Between 11 and 16, the child must give consent. This is a strict rule. You can't have access unless the child gives consent. If the child is not capable of giving consent, okay, then there must be there must either be a deputyship or it must be clear it's in the child's best interest. Bear in mind that the child's right, it's the child's right, so there's got to be a strong reason to overrule the child's wishes. If the child doesn't have capacity, okay, then obviously that's slightly different, but again, the deputyship is required. When a child reaches 18, deputyship or LPA is required if they don't have a capacity. Next of kin, parental responsibility, all that sort of stuff doesn't matter. I would point out next of kin, as commonly in law, does not matter here. It's never been an issue. It's never been legally recognised in this area of law. Now, obviously, children grow up. And you certainly don't want to be having access to children's records when they become of age. So there's got to be a process for general practices to remove parental access. Generally, practice will remove it around the age of 14 and ask the patient, that is the child, to renew it if they want their parent to continue having access. Or they can simply ask the parent regularly. It's no set process on this, it's just got to be reviewed. For those here who are patients between 11 and 18, if you're a child listening to this, bear in mind it's your data and your rights, not your parents. So don't be afraid to speak to your doctor if you're not happy with your parents or anyone else having access. And if you do have concerns about it, please discuss them with your doctor. Okay, that applies to adults as well. If you're granting access, don't feel you have to grant access to anybody. So, in summary, proxy access can be granted by the patient to any person they wish. For children, a parent can apply, but the child must consent to the access if they're over 11. And access for parents is generally withdrawn sometime between 14 and 16, but children can then request to put it back if they want. And for adults without capacity, then we have to ensure that either an LPA, lasting power of attorney, is available or a deputyship. Proxy access is not a right. Oh, sorry, don't forget the deputyship has to be for health and welfare. It can't be for property and property and finance because they're two completely separate things. Proxy access is not a right, it's a privilege, and it can be refused for a number of reasons by the GP, especially where the GP thinks it's not in the patient's best interests. So please feel free to put any questions in the comments and I'll try and answer them for everyone. If you do have any questions about the process and you're a customer, please feel free to contact us via the usual contact routes. For anyone else, if you're interested in taking up DPO services from us, feel free to contact us on sales@excathedra.solutions. We're always happy to hear from you. Thanks and goodbye.